We brought this motion to vacate the default order in under 30 days, which in its parallel, under the court's authority for a motion to vacate default judgment, moving to vacate the default judgment within 30 days is prima facie demonstration of due diligence. And
all right, that's Ms. Schmidt. I'm good.
okay.
Mr. Johnson, go ahead with your argument.
Yes, Your Honor. The main sticking point for them is that they didn't, or the HOA is that they did not have adequate notice. I created a timeline in
Well,
the.
I know you did, but let me ask you this: when you filed ex parte for default,
Yes.
did you serve Mr. Hutchinson, who had appeared in the case at that point?
My dispute was that he had not appeared, Your Honor.
But he had appeared, and you told the court in your ex parte filing he hadn't appeared.
Yes, because I included the attachment as well as the notice of appearance, disputing that constitutes an appearance. Because there's nothing in there saying that he intended to defend. It was only that he was going to find a law firm and mention attorneys and requesting more time.
Yeah.
It wasn't actually anything to do with an appearance itself, other than the title.
The law requires, if he has appeared, and he did, it was a notice of appearance. So I don't think you had to serve the HOA, your default, but you had to serve him. Any party who has appeared has to be served a motion for default. Also, if a party has appeared, you can't submit it onto ex parte. You have to put it onto a docket. He had the right to appear and come here and say, hold on, hold on. So I am going to vacate the default. I think the motion for default contained statements to this court that were inaccurate. And I find that Mr. Hutchinson, who had appeared, was not served that motion for default. So I will vacate the default. I am going to require that Mr. Hutchinson, the defendants, I guess they can figure it out, but the defendants are going to be given both a deadline for filing an answer. You've been in the case now since September 19th, I believe. I would have assumed that we would see an answer by today. Most people show up on this docket and have the answer, but I'm going to give you 1 week to October 8th to get an answer filed.
Is point of clarity, the default was ordered against both defendants, and you're vacating it against both defendants?
I am vacating against both defendants. The statute is clear that where a default is requested has to be served on. If any party has appeared, that party needs to be served. Mr. Hutchinson should have been served the motion for default.
Okay. Thank you. And does that 1 week deadline to file an answer apply for both parties?
Yes,
both
it
defendants?
does. Yes, it does. So there's no reason. Mr. Hutchinson's known about this case for a long time. Ms. Schmidt, your firm's been on for a couple weeks now. There's no reason that answer shouldn't be in by next Wednesday.
Understood. Thank you, Your Honor. Okay. I did not submit a proposed order. I have one prepared. I can email to you if that's helpful to the court.
I think given that we have at least one pro se party, I think we should set that on next week for presentation. So have that served on Mr. Johnson and then submitted to the court, and we'll review October 8th at 2 o'clock.
Your Honor, if I could
go ahead.
There is another matter before the court. It's for a injunctive relief. I would like to hold off on that so I can actually serve the other parties.
Yeah, so that's actually, it has not been, you filed it, but you didn't note it on for any motion docket. So that is not before me today.
Really? Okay.
I'm not lying to you. It's not on.
No, I didn't. I just went for a Principe. That's why I was, okay. All right. Thank you, Your Honor.
Yep. You are welcome.
Thank you, Your Honor.
Okay, let's go to 9 and 10, 25-2, 92608, and